This guideline, what I always see is not just the conduct that gets charged, whether it's under Guideline F, inability or problems with finances, or the problem with alcohol. It's the way these get answered. Let me just read some of these questions on a financial record. Have you ever had a judgment entered against you? Have you defaulted on any type of loan? Have you had bills or debts turned over to a collection agency? Have you had any account or credit card suspended, charged off, or canceled for failing to pay? This isn't, these two, and I always see folks get tripped up here. Have you been over 180 days delinquent on any debt? Are you currently over 90 days delinquent on any debt? I've seen that 90-day question answered incorrectly. Person didn't even know about it, and now they charge this Guideline E. You've been untruthful. You're not using candor. And these judges, let me say a word about the judges that we face at these hearings. These judges are good folks. I mean, I've been uniformly impressed. In fact, one of the judges was my commandant at the Army's law school when I was there. So fast forward 20 years ago, or 20 years later, and there he was. Now, on that one, he ruled against me, if you can believe it. But I like to think it was more the facts than my presentation. But I've seen people get tripped. This is where they get tripped up. It's that candor that these judges, and I just said they're good folks, but if they get a little, I guess, squirmy feeling about the candor questions, I mean, they can use that to knock out a clearance. So that's a pretty tough, and when people are filling this out online, I mean, I've looked at it online, and it takes some time, and it's a little complicated and convoluted when you're filling this out online. I always tell folks, if I have people call me to say, look, how should I answer some of these questions? I always tell them, don't answer it online. At least type up the question and answer for me. Let me see it, and we'll kind of talk it through and see if we can come up with at least a cogent response that makes some sense. So that's that guideline. Guideline F is financial considerations, and that's for a person who's financially overextended. So some concerns or mitigating factors the government will use to grant a clearance is that the behavior was not recent. It was an isolated incident. The conditions resulted in behavior that was largely beyond the person's control. A loss of employment, I've had that. Business downturn. I had a great guy who started a business, and I won't go into those details, but started a business, and a big store came in and competed directly with him, lost his business. But we were able to show that was the cause of his downturn, and he kept his clearance. And again, a great guy. Unexpected medical emergency or a death, divorce, or separation. It also allows for financial counseling or legal ways. It specifically says in there legal ways to tend to your debt situation. So that's where you've heard Amy talk about bankruptcy. And we get this question quite a bit. If I file bankruptcy, what's the effect on my credit? Or what's the effect not only on my credit, what's the effect on my clearance? And here's the general rule. This is kind of unwritten, but what I've seen, one bankruptcy in a lifetime, as long as there's nothing more, there's not a DUI, I've had it out, DUI, drug running, some other things like that. As long as if there's just one bankruptcy, no effect on the clearance. Two bankruptcies in a lifetime is potentially a problem. And there's a way to maybe kind of navigate around that, and it's something we talk to our clients about. But that second bankruptcy can pose somewhat of a problem, potentially. But a bankruptcy and something else. So you have this Guideline F, financial overextended, and then maybe if we have drug issues or alcohol issues, that can create a problem. But just one bankruptcy and nothing more, no problem. Guideline G is alcohol consumption. And the conduct that can mitigate that there is that the alcohol-related incidents do not indicate a pattern. I think one DUI is okay. Well, it's not okay, but one DUI, you could still keep a clearance as long as you've kind of taken care of the issue. I think two DUIs is a problem. I've had a DUI and a couple public intoxications when they're younger, potentially a problem. Let me say something real quick, going back to that question, the questions I was reading. Have you been convicted or charged with a felony? Even that question, I've had people answer no when they were charged with a felony, but they pled it down to a misdemeanor. A felony is defined simply as over a year in jail and generally over a $1,000 fine. But that year in jail is kind of the linchpin for a felony charge. So answered no, and the judge in that case made a huge issue that, hey, you lied, you weren't, candid. Well, I pled it down, so I thought that's really what the question meant. Well, no, the real question was, we just kind of get into that parsing word. So, let me talk a little further about the alcohol. So again, as long as there's no pattern there, as long as there's an intent towards sobriety and there's some type of, I've had folks that go into AA and testify to that. I had one person who didn't really do AA, but went to his minister quite a bit, who was actually familiar with the AA type programs, who testified for us. And again, wonderful witness. The gentleman was wonderful. The applicant was a great guy. He kept his clearance. Drug involvement. Drug involvement can be a little trickier, and I always tell folks, again, you've got to answer this stuff truthfully, because when the Army vets these clearances, they start going, they'll do a pretty serious background check. And if they have other folks that have maybe been convicted of something and you've answered no, it gets real tricky. But as long as the drug involvement wasn't recent, and most importantly, if there's a demonstrated intent not to abuse drugs again, if they see that in writing, and now this is the time a rebuttal statement is pretty effective. They see that in writing, that'll kind of go a long way. So that's really, bear with me, I'm kind of losing my papers here. That's really it with the guidelines. That's where we see most of the issues. Now, what happens at the end of these hearings? And again, they're thorough hearings. I didn't mention that there is a court reporter present. The court reporter takes down everything that's said, both by the applicant, the department counsel, the judge, takes down everything. And usually these transcripts run a couple, 300-400 pages. This is the one time the government does give the applicant a free copy, fortunately. From there, the judge makes his decision, and it's always in writing. The applicant wants it right there. But the judge issues his decision in writing, and they're very, very thorough, very thorough. And I tell folks, once the judge makes that call, the one good thing about this process, the judge is the sole arbiter, if you will, of this decision. If he says, even though he works for the government, and sometimes even though he dines with department counsel at lunch, if he says keep the clearance, by and large, the person will keep the clearance. Now, the government has the right to appeal. So does the applicant if there's an adverse decision. But that appeal process is very quick. It's 15 days. You've got to have an appeal submitted. And I always tell folks, I hate that appeal. If you're appealing a judge's decision, chances are it's not going to be good, or it's going to be tough, I should say. The government sometimes appeals. I've had some cases where the government appeals. I view it as a case of sour grapes, and I guess they could view it if I appeal the same way. But once that judge, and those judges' decisions are pretty thorough, like I said. So one last thing, can you appeal? So let's say you get a negative decision by the judge, you submit an appeal to this appeal board, and the appeal board still denies you. What can you do then? You're kind of stuck. You can reapply for a clearance in 2 years. By then, you kind of know what the issues are, whether it's a situation of getting into some type of sobriety program or managing the debts a bit better, doing something about that, or whatever it is. You cannot appeal to federal court. I've had some folks who wanted to try that. Hey, let's go. I want to go to court. I think I've been wronged. What the federal courts say is, we're not touching security clearances. This is solely the purview of the government. The government decides we don't know anything about it, though they think they know about everything else, but we don't know anything about this and we don't want to mess with it. So you're really stuck once you get to this point. Let me touch on two real quick things that are in your materials. I want to talk, now I'm going to switch gears and go back to Fair Debt Collection Practices Act. Real important consumer law. It's 6 pages, and it's in your materials, and it is a great tool and mechanism, especially in this climate, as Amy said, if folks are being harassed by debt collectors. And there's an awful lot of that going on. I always tell folks the first part of that, the statute's actually in your materials. Again, 6 pages. The first part of it talks about congressional intent. It was, the law was enacted in 1977, the fall of 77. And what Congress said in the first part of that law is, we think there is abundant evidence of abusive debt collection practices, and essentially we got to stop it because it leads to all sorts of bad things. That's 1977, Congress says that. You know, fast forward to where we are today, 30 plus years, and that's before the real explosion of credit card debt and that type of thing. So there are ways to put debt collectors back on their heels, and there's a lot of stuff that is done out there that they're not allowed to do. One last thing. Fair Credit Reporting Act, that's the law that applies, and again, as a follow-up to Amy on consumer bankruptcy, Fair Credit Reporting Act is the law that applies when you have problems with your credit report. Credit report shows errors. I think the studies are that over 50% of all credit reports that are out there have errors. And this is the law that talks about how you go about correcting it. Most important thing I can say here is make sure you get your free credit reports from the government site. It's annualcreditreport.com. And again, some of that information's in there, but only use that site. Don't be lulled into the ads that talk about, I'm going to not name them, but there are other sites and you may have the jingle in your head. Only use annualcreditreport.com. That's the free government site. If you use any other site and if you do it online, here's the trick. If they mess you over, if your credit report has errors, you're not going to be able to sue to correct it. You enter into what's called binding mandatory arbitration and you waive your rights to sue. And it's fine print. You won't even see that language. And I've had a number of clients get stuck that way. So I've got the form and appreciate y'all's time. Thanks.